coming to order at 4:05 on June 18th, 2013. Ms. Osbury, would you call the roll, please?
Yes. Member Nee?
Here.
Nee present. Member Grant?
Here.
Grant present. And Chair Washburn.
Here.
You have a quorum?
All right. I don't anticipate any changes to the agenda. It looks like the parties for item number 3 are here. Members, do you have any comments? Any changes? Okay. Let's get started then. Ms. Osbury, would you read item number 2, please?
Item number 2, adoption of April 16, 2013 regular meeting minutes.
Madam Chair,
Member Nee?
move to adopt.
Second.
Madam Chair?
Member Nee?
Yeah, I found one minor error in here on item 8, first line, where it says Assembly Bill AB 400. The AB stands for Assembly Bill, so it can be deleted.
All right. That one got by me. Do you see any more?
No, that's, I've read the minutes and they seem to be in order.
Okay. Are there any public comments on the minutes from our April meeting? Okay, seeing none, Ms. Osbury, would you call the roll, please?
Member Nee?
Aye.
Nee, aye. Member Grant?
Aye.
Grant, aye. And Chair Washburn?
Aye.
You have 3 ayes.
All right, Ms. Osbury, would you call item number 3?
Item number 3, file 12049, hearing on the status of the order of determination of Ray Hartz Jr. against John St. Croix, Executive Director, Ethics Commission, for allegedly committing multiple violations of his July 23, 2012 minutes.
All right. Mr. Hartz, you have 5 minutes.
Thank you, members of the Compliance and Amendments Committee. If Ms. Osbury will let me know when I have 1 minute, please. Reading from the actual order of determination of May 23rd, 2013, in this case, down in this decision and order of determination, it says the Ethics Commission shall continue to place 150-word statements submitted not only by Mr. Hartz, but by any member of the public within the minutes directly following the item addressed in public comment. I have been fighting this issue for 3 years now. And it is a constitutional issue. It is a protection of free speech and a prevention of censorship and abridgment of free speech. The Supreme Court of the United States, as well as the state of California, have both ruled that written statements coming as a result of public comment were an extension of the First Amendment free speech rights. And one of the reasons I fought so hard and long for this is that there were very often cases where dissenting opinion, which is protected by the Brown Act particularly, was kept out of the official record with the effort to hide certain irregularities. This started primarily with the Library Commission and the city librarian, who pointed their fingers at one another. The city librarian said, well, I'm not the one who determines where these statements go. It's the Library Commission. And then the Library Commission would point at the city librarian and say, no, it isn't us that decides it. We work on the recommendation of the city librarian. So basically, what we get is these situations where everybody wants to deny responsibility. Now, in this particular case, Mr. St. Croix came before the task force the last time and said, we've accommodated Mr. Hartz by placing his 150-word summary in the body of the minutes where the law says they're supposed to be. But what he would not and refused to and continually has refused to address is whose decision this was. There, as far as I know, has been no discussion before the Ethics Commission as to this policy. In other words, Mr. St. Croix has simply directed someone on his staff to place these statements in the appropriate position in accordance with the order of determination, but there is absolutely nothing to prevent someone, if someone is not watching, that they reverse that going forward. I think it is critical that the discussion be held at, and this is the same thing that's happened at the Library Commission. Mr. Herrera went before the Ethics Commission and said, oh, we're changing our policy to put this in the body of the minutes. They have not done so. And one of the members of the Ethics Commission, Commissioner Rennie, said, well, if you didn't change the policy, I would consider that a willful violation. But as long as you're changing it, good for you. But it hasn't been changed. It wasn't discussed at the Library Commission meetings. It hasn't been discussed at the Ethics Commission. They are simply using an administrative method to put these in, and my fear is that as soon as I or others stop looking, they will simply revert to the city attorney says we can put it somewhere else. There is no doubt in my mind that the reason the Library Commission and the city librarian wanted these 150-word summaries kept out of the Library Commission meeting was because they were directly challenging financial dealings of $50 to $60 million having to do with the Friends of the San Francisco Public Library. I think the Ethics Commission is on the same tack.
1 minute.
Thank you. Is on the same tack in the sense that they do not like derogatory, in their mind, statements which are really, honestly, dissenting opinion in the minutes. And unless they are put in a position of saying this is now our policy, that the 150-word summaries will go in at the appropriate place in the minutes, they will simply wait until an opportunity to revert to the old thing, and we'll be back right where we were, which is their ability to abridge and censor public comment, which is something that this law, the Brown Act, and the Constitution of both the state of California and the United States Constitution prohibit.
Thank you. Is there anyone here to offer evidence in support of the complainant? Okay, seeing none, the respondent has 5 minutes.
I don't have a statement.
All right.
Facts and evidence.
Are there any facts and evidence in support of the respondent? Okay, seeing none. Members? Member?
Mr. Hartz, please.
Yes.
Okay, the order of determination simply states that the Ethics Commission shall continue to place 150-word statements directly into the minutes. It doesn't. It doesn't go as far. The order of determination does not, to my perception, go as far as saying that the Ethics Commission shall meet and vote on this. And one of the real bottom line question here is whether the order of determination has to this point been complied with. What has it, as near as you can tell?
As near as I can tell, it has. But the question really comes down to whether or not this order of determination will continue to be followed, or it is simply a transient thing so that when somebody goes away, they can go back and change it. And the discussion throughout all of these cases has been one where the commission representative, in most cases Mr. St. Croix, came in and said, it isn't me making the decision, it's the Ethics Commission. It isn't the Ethics Commission making the decision, it's me. And so as a result, who is responsible for seeing that this order of determination is enforced and continues to be enforced? That's the big issue.
Thank you. Mr. St. Croix, could you approach the microphone, please? Thank you. Has the commission, or have you, or any of your senior deputies issue any kind of written guideline on this, saying that henceforth written comments, written summaries of comments provided by members of the public, as long as they do not exceed 150 words, shall be included in the body of the item that they address?
No. The staff does that because I've directed them to do it.
Okay, have you directed them in writing or verbally?
Verbally.
Okay, so what guarantee is, Mr. Hartz asks what guarantee is there that going forward that kind of compliance will continue?
There isn't one.
Okay, thank you.
I have a question. Mr. St. Croix?
Yes.
The order of determination states that the Ethics Commission shall continue to place 150-word statements submitted not only by Mr. Hartz, but by any member of the public within the minutes directly following the item addressed in public comment. So what do you understand that to mean, that statement that I just read?
That it's the will of the task force that this policy continue.
And so does that mean that the Ethics Commission could, or you could decide at some later date to stop doing that?
Correct, because I don't believe the ordinance requires it. And neither does the city attorney.
All right, well, we differ on that, as you well know.
Clearly.
Okay, thank you.
Mr. St. Croix, I just have a quick question. So just as far as the order of determination, you guys have been putting Mr. Hartz and all the other public comments in the body of the minutes
Beginning this calendar year.
beginning this calendar year. So you guys went back and put those. Okay, got it. Thank you.
Oh, before, Mr. St. Croix, if there are no other questions, members, do you have any more questions? Now's the time that you can have 3 minutes to say anything further on this matter. Do you have anything further to say?
No, I mean, it's my intention to continue to do this, but I maintain that this is a courtesy to Mr. Hartz and other people who submit written statements. And that's all I have to say.
Okay, thank you. Mr. Hartz, you have 3 minutes.
And again, if Ms. Osbury will let me know when I have 1 minute left. Again, I really take exception to this idea that putting someone's political, constitutionally protected free speech in the official record is a accommodation to them. I don't think any of you appearing before any city body or in any political or governmental agency and making testimony would consider it some sort of a gift to you to have your statements accurately represented in the official minutes. One of the reasons I fought so hard on this was because I spent 2 years watching them balderize my comments, eliminating things they didn't like, and putting down what they wanted in very short term. And I saw them do it to other people, just like we have another case coming up against the clerk of the board. Hers are one sentence. Mr. Hartz talked about various items. What the hell does that mean? Nothing. And that's what they want. This is not doing somebody a favor. Very frankly, I think to characterize it that is an injustice. And I don't really think that the Ethics Commission, the Library Commission, the Police Commission, and the Arts Commission have started to follow this guidance from the task force out of the goodness of their hearts. I think what they did was they had a quiet discussion with the city attorney's office, and the city attorney said, Mr. Hartz is right. The representation of his speech is an extension of his First Amendment rights. And you have to put it in. What they don't want to have is they don't want to have
1 minute.
Thank you. The discussion, because what they did for 2 or 3 years is censor and abridge my free speech and that of other members of the public who came to speak before them. And what they want to do is they want to do this little song and dance where they can say, well, I parked illegally Monday and Tuesday and Wednesday and Thursday and I was ticketed, but I parked legally on Friday, so I'm going to go into court and ask the judge to forgive the first 4 tickets because I've now got it right. And that's what they're doing here. They're trying to make it so that they don't have to admit that what they did in the first place was wrong, and that they compromised, abridged, censored, whatever you want to call it, my political speech and that of others, because it leaves them open to potentially a court case.
Thank you. Members, do you have anything? Member Nee.
Yeah. Madam Chair, I don't think this requires an actual motion. I think what we've seen here is that Mr. St. Croix is complying with our order of determination. However, this order of determination does not have finite duration. This order of determination is perpetual. It is. There is no end in terms of time to this order of determination. And if at some future date Mr. St. Croix or his successor decides to reverse the policy, then I think that's grounds for a new complaint. I do think that we need to mention all of this in the committee's report that will go to the full task force at our next full task force meeting. I think it might be a good idea for the task force to ask the Ethics Commission to address this as a policy issue. The Ethics Commission may not come down on our side on this, which is a risk we have to take. But I still think that it's something the Ethics Commission should address, and they should be aware that the Sunshine Ordinance Task Force has a definite opinion on this. And our opinion, the task force's opinion, is not without legal foundation. It's not without legal perspective. The last voting member Sunshine Specialist Attorney we had on the task force, David Snyder, agreed when this type of issue came before us, that inclusion of comment summaries in the body of the minutes was prescribed under law. That it has to do with the continuity and the flow of the minutes, the continuity of the flow of people being able to follow what goes on as they read through the minutes. So I think that when we give our report next month to the full task force, this is something that we should possibly take up and see if we want to take it to the Ethics Commission.
I agree with what you were saying, that Mr. St. Croix is in compliance with the order of determination, and the only issue is that this is something that, wasn't written or anything like that. But when we go to the full task force, I would like, if we want to, have an opinion, what is it that we are suggesting? Are we suggesting we go to the full Ethics Commission and say that we'd like to have this in writing? Is that what you guys want to go back to the full task force to say? Or just say that, we're in agreement that something more needs to be done? I think a problem is that we should be specific about what our suggestion is, whether, and that's something to be decided amongst the full task force, that we don't just, make it an order of determination that says that because he is in compliance with what we've done, that's, what we asked him to do, and he has been doing it. So I guess to Mr. Hart's point, specifically, what would we go back to recommend? So that's to keep in our mind when we go back to the full task force in July.
Member Nee.
Madam Chair and Member Grant, I would like to see the Ethics Commission adopt a policy and put it in writing.
Got it. Okay. So that's
So Member Grant, if we could ask that there be an agenda item, not just our report. I think, aside from our report, we should have an agenda item where we, on the full task force.
It could be a part of the result. It could be a
part of the
part of our
report.
committee report.
Yeah.
Okay.
That this discussion arose, and this is our recommendation.
Yes.
Okay, all
I
right.
think it needs to be.
And I just wanted to say for the record and to Mr. St. Croix representing the Ethics Commission that over the several years that we have been discussing this issue, underlying all of it, at least in my mind, was the principle, and it's in the Sunshine Ordinance, that our ordinance is very strict. We go beyond the Brown Act. We go beyond the CPRA. And we're charged to do that. And we're charged to, whenever there's an ambiguity, that we come down in favor of more open government. And so I agree that the language in the ordinance regarding where to place this comment might be seen as ambiguous, that some might interpret in the minutes to mean it's okay to put it in an appendix. But an equally reasonable way to interpret it is that it should be in the body of the minutes using the language we have in our order of determination. And given that either interpretation could be made by somebody who reads English, then I think this task force has come down on more openness, more protections for the First Amendment rights of the public. And I think for that reason, we have made the decisions we've made, and consistently. And I think when the ordinance is amended, and hopefully that will happen the next couple of years, there will be no ambiguity. We will make sure that the precise wording is in the ordinance, and then this matter will be forever put at rest, and it'll just become, good policy of this city to make sure that the minutes read as events transpired, and there's no guessing about who said what, when, and what they said, because they give their words to us. So we'll continue this discussion next month. Any more comments? Any public comment on this matter? I don't have to call it, I believe, but seeing none. Ms. Osprey, would you call item number 4?
I'm sorry, just for clarity, for this item, are you concluding it or are you leaving it open?
It's concluded,
Okay.
yeah. Not going away, though.
Okay. Item number 4, public comment.
Members of Compliance Amendments, I have 3 minutes, right? Let me know when I have a minute left, please. I may have told the story before, and bear with me if I didn't. I enlisted in the United States Navy in 1971, and it's really kind of a bizarre process when you really think about it, if you really read the oath that you take at the time. Because basically what you do is you surrender your free will. You agree to obey the orders of the officers appointed over you, the Uniform Code of Military Justice, and all these other things. And you really give up a lot of your personal liberty to do that. And part of the oath you take is to support and defend the Constitution of the United States. And it was a really transformative day for me, in that later on, as I was thinking about all the implications, because they don't hit you at the time it's actually happening, they just kind of hit you later on. I thought to myself, here it is. I'm in this country I've been alive for 21 years. I've always had the protection of the Constitution, and yet I've never really ever had to do anything to protect it. I got it for free. And I thought, what a blessing we have in the United States of America to have free speech and freedom of the press and the right to tell our government when we think they're doing something inappropriate or whatever it happens to be. When I came to San Francisco, I originally had this picture that I think most of the United States has about San Francisco being this liberal bastion where everybody is free to say what they want and they may say bizarre things, but everybody just kind of shrugs and goes, yeah, that's okay. But it's not. And especially with government bodies in this city, they really do have a pattern when they don't like what you say of trying to keep you from saying it.
1 minute.
And if they can't keep you from saying it, they try to keep it out of the record. Again, I went back, Thomas Mazzucco, the president of the police commission, the other night. I went back. He's already been found in violation of the ordinance for telling me I wasn't allowed to talk about certain things. And then 3 weeks ago, I made a statement. I quoted from Shakespeare. I made it very clear that I was making the statement about the report that had been given, and I did so both orally and in writing. And immediately on my using the quote from Shakespeare, he accused me of making a personal attack against the Office of Citizen Complaints Executive Director. They will look for a reason to take what you say, and if they can't shut you up, they will do what they need to say, you shouldn't be allowed to come here at all. I've watched it happen to other people, and I will not let it happen to me.
Thank you. Is there anyone else offering public comment? Okay, seeing none. Ms. Osbury, would you read the next item on the agenda?
Item number 5, Administrator's Report. In front of you, you should have a copy of the Administrator's Report. It's just one item that's pending before the Compliance Amendments Committee. That's 12058, Dominic Manucci versus the Recreation Park. It was recommended from Task Force on May 1st of this year.
Thank you. Would you read the next item on the agenda, please?
Item number 6, Announcements, Comments, Questions, and Future Agenda Items.
Member Nee.
Madam Chair, something has come across, I guess, all of our eyeballs during the past week or so that merits our attention, not as a task force, but as individuals. This is a sunshine matter. There is legislation in Sacramento that would make certain kinds of public records compliance voluntary rather than mandatory. This would not affect San Francisco because, fortunately, we have the Sunshine Ordinance. At the same time, it would affect the school district and the community college district. This is a bad piece of legislation. It's Senate Bill 71. There is information available at the websites of the First Amendment Coalition and Californians Aware. And I would urge that all of us contact Governor Brown and ask him either to remove those anti-sunshine provisions from Senate Bill 71 or to veto the entire measure. Those websites are firstamendmentcoalition.org and calaware.org.
Thank you. Are there any other comments, announcements? Member Grant? No. Okay. Do I hear a motion to adjourn the meeting?
So moved.
Second.
Without objection. This meeting is adjourned at 4:33.